Lila de Lima has secured victory after being acquitted in one of the two remaining drug charges against her.
Kung narinig niya na siya ay acquittal, siya ay napaluha. At siyempre, tuwan-tuwa siya. Nagpapasalamat talaga siya sa hukuman, nagpapasalamat siya sa mga kababayan natin, nagpapasalamat siya sa inyong mga media na sinabi niya hindi siya pinabayaan at patuloy na sumama sa kanyang laban sa panggigipit.
Former President Rodrigo Duterte accepts the acquittal of former Senator Lila de Lima in her second illegal drug case.
Ultimo, nasa kamay ng judge yung desisyon na yan. But based on my reading of the evidence, there really was not enough evidence to convict her. Dahil nung nawala yung testimonya ni Ragos, ay wala na rin basehan yung kaso.
2 down and 1 to go. Just one more case to hurdle and former Senator Lila de Lima may just become a free woman. But whether it's an acquittal or a conviction, de Lima's fight is nowhere near over. We talk about this tonight on the Chiefs. Welcome to this episode of The Chiefs. I'm Ed Lingao. With me tonight in the studio, Ana Marie Pamintuan, the editor-in-chief of the Philippine Star, and of course, Lucy Consoldes, the head of News 5. Ladies,
good evening.
Good evening.
So tonight we talk about de Lima's case. Of course, last week, na-acquit on the second case and one more to go.
One more to go. And in fact, bail pa lang siya. For resolution pa lang yung bail petition niya doon eh.
Yes.
So potentially mahaba-haba pa siya?
Medyo mahaba-haba pa. And we're not sure dahil mukhang lalabanan talaga ng Department of Justice. Etong pangatlong case, di ba?
But you wonder tuloy how much of Rafael Ragos's recantation affected the outcome, meaning the acquittal, di ba?
Di ba hinahabol nga ng DOJ, di ba? They wanted the rebuttal nung recantation.
Sana, di ba?
Pero hindi na nga daw pinayagan.
Oo, right.
So anyway, siguro kung ano man yung ibubuhos nga yan dyan sa pangatlo.
And whether Ragos's testimony has any bearing on the third case and whether he was a witness in the third case.
Oo. At saka, alam mo ang hirap dyan, kawing-kawing yung mga case, di ba? Yung tatlong case. And in fact, may mga common na mga witnesses, no? Ang dami nga eh. Tapos, you wonder tuloy also whether the acquittal from the first two cases will also somehow affect or influence the outcome of the third. Siguro naman, ano?
Pinaghahandaan na nga yan ang
Because
prosecution.
generally you're talking
sigurado.
about more or less the same allegations, only with different personalities involved.
Exactly. And since this is a criminal offense, di ba, dapat beyond reasonable doubt. Eh, na-acquit na ng dalawa, di ba? So, parang it should stand to reason na medyo humina yung third. Well, but that's not for us to say.
Ay, may isa pang pahabol yung storya the other night sa Senate hearing na sabi ni Secretary Galvez, up to 8 out of every 10 soldiers daw might just take early retirement kung itutulak.
Enlisted personnel, sabi niya.
In other words, they're just staying on because of the benefits precisely, no?
Hindi kasi 20 years of service, pwede ka na mag-retire.
Oo, yun na nga eh.
Yan ang
So, pag
ni
pinago
Benjo,
yun, di ba? At ginawang mandatory 57 ba yan, di ba? Yan ang gusto
So for
nila
example, if you enter the service at 18, dahil for example,
38, pwede ka na.
38, tapos you find another job. Buhay na buhay
Lifetime
ka,
yung
Lifetime pa yung
pension mo. Kaya yun nga yung sinasabi ni Benjo, no? Kaya although, well, matagal na yan eh. Medyo nagkapatong-patong na yung problema, no? So we don't know. Medyo malakas yung pushback, ano?
Plus yung indexing. I was looking at the US pensions sa US military sa atin kasi more or less 100% after retirement. You could get your first 3 years as a lump sum. So for example, if you're a general, you retire with 149,000 peso na monthly salary, you get 5.4 million. That's lump sum for the first 3 years. And after 3 years, you get your regular 150,000, 149,000. So for staff sergeant, you get 42,000 per month and you get 1.15 million as lump sum.
Laki, di ba?
Substantial.
At tumataas pa yan tuwing magkakaroon ng...
Sa US, they get 50% of their basic pay plus 2.5% for every year.
Which is how it is for all the other government positions here. Hindi ganong amounts, but it's not 100%.
Yun nga ang sinasabi dito sa MUP lang eh.
Oo.
Military and uniformed personnel lang eh. Hindi sa lahat ng gobyerno.
But it is a touchy issue. It always has been and always will be a
Yes.
touchy issue, and that's why a lot of administrations have taken a
Yes.
hands off.
Right.
And even
policy there.
Congress, ano?
Yeah.
Military kausap mo dyan, mahirap eh.
Anyway, we're bringing in our guests about the Lima case after a quick break. The Chiefs will be right back.
With us tonight are two lawyers. Joining us via Zoom, Attorney Dino De Leon, lawyer to former Senator Laila De Lima, and here in the studio, Attorney Harry Roque, former presidential spokesperson of former President Rodrigo Duterte. Good evening, gentlemen, and welcome back to the program.
Good evening.
Good evening.
Evening.
Pleasure to be back.
Welcome in person.
Okay, I'll get the first reaction, of course, from Attorney Dino De Leon via Zoom. Let me just, before we move on, let us just clear out some of the legal questions we have here. So there are three cases. Could you just briefly describe to us these three cases? Two already acquitted. And the last one, that's what we're awaiting as we speak, right? Could you just explain to us the differences of the three cases?
So these are three conspiracy to commit drug trading cases filed against Senator De Lima, criminal case 165, 166, and 167. They all basically follow the same narrative. The only difference is there are different respondents or accused, and there are different indicative dates. So in criminal case 165, that is the case against former Senator Laila De Lima, against Ronnie Dayan, and formerly Rafael Ragos, until such time that the prosecutors eventually dropped the cases against him and asked him to testify against Senator Laila De Lima. That's criminal case 165.
Okay.
Criminal case 166 is just Ronnie Dayan and Senator Laila De Lima. And in criminal case 167, the same accused plus General Bukayo, who used to be the OIC of the Bureau of Corrections.
Okay. How much of the acquittals were a function of the recantations, not just of Rafael Ragos, but also a couple more others before him, including Espinosa?
Well, if you're referring to criminal case 166, even without the recantation of Ragos, the court dismissed it because of weak evidence presented by the prosecution. The court there essentially granted our demurrer to evidence. In criminal case 165, which is the recent dismissal, the court pointed out that the recantation of Ragos actually weakened the case of the prosecution, because if you would recall, when we filed a petition for bail previously, such was denied by the previous judge, and the evidence that was cited was the testimony of Rafael Ragos. Mm-hmm. So without the testimony of Rafael Ragos, him recanting, him actually saying that he was forced, he was coerced, he didn't have a choice, and he was specifically coerced by then Secretary Vitaliano Aguirre. The court found that there was reasonable doubt, enough for Senator De Lima to be actually acquitted in that particular case.
Okay.
Sir, let me reframe that lang, specifically sa case number 167. How much of 167, the one that is pending right now, is built around the testimony of Ragos, if at all?
Yes.
No, Rafael Ragos is not a witness in that particular case.
Mm-hmm.
So that will not have any bearing on the third case?
Well, our stand is the consistent pattern being shown actually by numerous witnesses who already recanted showed that the previous administration used the strong arm of the state to persecute a human rights defender in the name of Senator Laila De Lima, only because she was actually upholding human rights, defending human rights, investigating the numerous murders that were happening during the previous regime. Mm-hmm. So this consistent pattern shows actually that the state was heavily involved in the persecution of Senator Laila De Lima. Besides, it's all the same tainted witnesses. It's all the same tainted evidence that were manufactured by the highest officials of our land during that point in time. So we think that at the end of it all, such kind of, there will still be an impact insofar as criminal case 167 is concerned.
All right, it's time for your reaction to this persecution. That's the word, and they're building their whole defense on that, no?
I don't see how there can be a persecution when the court was very clear that the evidence did show widespread trade in dangerous drugs within the Muntinlupa premises. And that the only reason why the court said there was reasonable doubt was the recantation of Ragos. No? Now, let me state first that Ragos did not just testify before the court. He executed an affidavit which must have been used for the preliminary investigation of the case in the fiscal's office, which means he must have taken an oath as well, no, before the fiscal's office. He testified before us in the House when I was a member of the House. I remember the time when he testified. He also took an oath, no, and affirmed the truth and veracity of everything he said in his statement. He testified in the Senate, and mind you that his testimonies in the Senate and the Senate and the House were widely viewed by the public, no? Again took an oath that everything that he said in his affidavit were true, no? And of his own personal knowledge. No? Then he testified in court as well. No? So my first point is, come on, a recantation made once will overcome positive affirmation that he was saying the truth 4 times before in bodies that could send him to jail indefinitely for telling a lie. Because the rule is, if you tell a lie before the Senate and the House of Representatives, you can be detained indefinitely. And we have seen many people suffer this fate.
So why did the court accept the recantation at its face? Did the court not know that? Was this something that had to be pointed out to the court?
Well, the court said that without the testimony of Ragos, then the case against De Lima could not be proven because there had to be evidence showing that there were actually 2 deliveries of 5 million pesos from the drug lords. My point being is, number one, he was not the only witness presented by the prosecution. There were more than 10, no? And in fact, they even used AMLAC records to confirm that there was such a money, no, that came to one handstand. No? So that was a matter of record, no? Supported by AMLAC documents. No? Number two, there was also an aide who accompanied Ragos when he delivered at least once, no, 5 million to the residents of Leila de Lima. No? So I don't understand why the court said that without the testimony of Ragos, it couldn't have withstood the scrutiny. No? Now, furthermore, the decision ran counters, and the court admitted it in its decision. No? It runs counter to jurisprudence saying that, number one, it's dangerous, in fact, to accept recanted testimonies. Why?
Yes.
Because number one, it makes a mockery of sworn statements made in court. Number two, it subjects the truth, the search for the truth, to the caprice and whims of witnesses. No? And that is why the jurisprudence is courts frown upon admitting affidavits of recantation, particularly in this instance when he affirmed the truthfulness and veracity of everything he said in at least 5 forums: Fiscal's Office, House of Representatives, Senate, when he testified. No? And there was also a 1-hour video interview featuring Ragos, confirming everything that he said in his sworn statements. And I need to add, no? I was probably one of the first to hear his testimony. I remember that when I was a member of the 17th Congress, I got a call from a former politician asking me to go to Soler. And I was then attending a christening of a child of Congressman Mikey Romero, and I was very hesitant to leave because I haven't eaten then, but it was a very urgent call to go. So I went. I didn't know who Ragos was, but he was introduced to me by the former politician, his deputy director, Ragos. And I said, "Oh, good to meet you. What about?" Then he started telling me information that he had against De Lima. And I was shocked. Why? He was deputy director of NBI. He was an appointee of De Lima because he was then Secretary of Justice. And there he was saying that in at least 2 instances, he delivered money to Leila de Lima from drug lords. No? So I said, whoa, this is big. Now, it is also in this meeting that would prove that former President Duterte had nothing to do with the cases against Leila de Lima. This was at a time when I was still a congressman. He was very new. It was the first year of the president then, former president. And it was the former politician, no, who actually introduced me to Ragos. No? And my impression was he was the one behind the build-up of the case against Leila de Lima. The motivation? Because during the time when she was the Secretary of Justice, she engaged in a witch hunt against his former politician. And he got information that Leila de Lima, the Secretary of Justice, was herself involved in widespread drug trading in
So at
Muntinlupa.
that time, you were still not with the Duterte
No,
administration?
I was a congressman, very critical then of President Duterte. And I was shocked, quite frankly, when I found out who Ragos was. No? There was no indication that
so what do
he
you
was,
make of this?
anyone was
Yes.
forcing him. No?
Pero ngayon well, ito na nga na-dismiss na and the prosecution was complaining, hindi nga daw pinayagan yung request nila for rebuttal of the recantation. What might be the legal remedy? Meron
Well,
pa bang legal remedy
yes.
for this one case lang?
Well, you know,
For
there's
the
such a thing
prosecution.
as the right of the accused against double jeopardy. No?
Yes.
But the court has since relaxed the rule that once acquitted, you're acquitted. No? Because now there is an established procedure by which the state can appeal acquittals on the basis that they were denied due process. And I would say that given the established jurisprudence, that courts really frown upon recantation, particularly of an affidavit that he swore to at least 5 times, then perhaps it has a good chance.
Sir, we understand your point. 5 fora,
Yes.
sworn statements,
Yes.
and all that.
Including my personal meeting
Yes,
with
sir.
him. No?
Yes,
And
sir.
there was no one intimidating him in that very luxurious
But in the end, is it a matter
suite.
of is it a matter of numbers? 5 times you said this versus 1 time when you said I was forced to do it.
People versus Ubina. It's not a matter of numbers. It's a matter of witness credibility. Why would someone who attested to the veracity of his statements at least 5 times in public forums all of a sudden change? What the court should have looked at was the relationship between Ragos and Leila de Lima. He was, after all, very close to Leila de Lima, close enough for him to be appointed as deputy director.
Pero sir,
If I understand, they're also compadre, comadre, no? I don't know if that is true, no? But that's what I hear. No? And that should have been considered by the judge. No?
Can he be indicted for perjury?
I hope so, 5 times. And I hope he's cited for contempt by the Senate and the House and imprisoned indefinitely for lying.
Who
And-
could
and
do
yours-
that? Who could do that?
Well,
Anyone?
unfortunately, the congresses where he appeared have long expired. Had the 17th Congress been in session, then he would have been sent to jail, as well as the 17th Congress, not for the Senate, because that's when he testified. But you know, under our constitutional framework, after particular congresses, it's a different Congress already. No?
Yeah.
And
But
you're
what could have been the
saying-
motive? What could have been the motive for him saying this 5 times before, nung panahon ni President Duterte, and now saying na I take it all back?
Well, I think the motive is the relationship. And after 5 years or 6 years, perhaps, no, he figured, well, after all, we had good relations. I wouldn't have been deputy director had it not been for Leila de Lima. And, you know, she's been incarcerated for 6 years. Maybe that's enough. That's why I'm recanting.
But sir, doesn't that work against him? I mean, you're risking. I mean, 5 times you swore, and then you suddenly
Yes.
say na, teka, friends pala kami. So
Yes.
babuhin ko.
Well,
Why
in
would
the
you do
first
that?
place, it doesn't really work against him. It's a fact. He would not have been appointed deputy director if he did not have very close relations with Leila de Lima. He cannot deny that. Now, yes, it works against him because I cannot understand by what logic people would believe that a person who testified at least 4 times to the truth and veracity of his statement could get away with saying, oh, despite jurisprudence, I changed my mind now.
So what made him?
That's precisely
what's
the
your-
warning of the
Oh,
Supreme
bring it
Court.
on.
Yeah,
Let's
let's
bring in
bring in
Attorney
Attorney De Leon. Attorney De Leon, your reaction, please, to this mouthful. What seems to us to be, well, a good basis for wondering why Rafael Ragos had recanted.
Well, it's unsurprising that Attorney Harry Roque is trying to relitigate the judgment of the court. The court has already spoken that, in fact, Leila de Lima is actually innocent. But despite his attempts to relitigate the issue, he's not counsel there. Maybe he can be a prosecutor someday. You know, let's remind ourselves that.
What's the point of saying
despite the
that?
fact
I don't see any relevance. No, go to the issues.
Despite the fact that Rafael Rago actually 5 times took an oath it is also very clear that he used to be actually a witness, an accused in this particular case, and he was dropped by the prosecution eventually, even though he was not a state witness. That's first. So what would be the motivation? The fact na ginigipit siya, and the fact na kailangan siyang bitawan at hindi isama sa case para mag-testify siya. So it was very clear in the chain of events that in fact ginigipit siya. That's first. Second, Attorney Harry Roque said a while ago that there was this anti-money laundering council witness, the same witness who said, and you can take a look at this in the court records, that in fact there is no investigation linking Laila de Lima to any improper flow of money. That was actually stated by the Anti-Money Laundering Council witness by the prosecution. That's second.
Okay.
Third is they were talking about the aid of Ragos, which was actually also an incredible witness and was not believed actually by the court. The memory of Attorney Roque when it comes to jurisprudence or recantation is quite selective. There are a lot of recantations in jurisprudence that were actually honored by the court because they are credible and they are actually consistent with the right of the accused to be genuinely heard. No, so ultimately, Attorney Harry Roque said a while ago, parte siya ng mga investigation in the past. It's unsurprising. It's surprising though that he is a brilliant lawyer, a human rights lawyer supposedly, but he did not see all of the inconsistencies of Rafael Ragos's testimony, including the fact that when he was supposedly giving his testimony in Soler, it was a Sunday, for example, and all of the prosecutors or even the one who actually notarized his affidavit was there, who was coming from the public attorney's office. By the way, I just want to correct that in fact the rebuttal of the prosecution was allowed. They were actually allowed to present the notary public. And all of these things were confirmed. The Sunday, nandun ka, nagnonotaryo ka, wala kang order from the public attorney's office. Rafael Ragos was cross-examined numerous hours or a number of hours by the prosecution, and ultimately his recantation stood the test of the prosecution. After 2-3 hours, ilang settings na kino-cross-examine siya, and after the rebuttal testimony of the prosecution. So it's not true na, alam mo yon, na hindi na-test yung testimony ni Ragos in terms of his recantation.
Well,
Attorney
to
Harry,
begin with,
yung
there were
AMLAC,
lots of personal attacks which were unnecessary. I was testifying on a personal experience I had with Ragos. My meeting with him in Soler was separate from his meetings with the fiscal. In fact, when I met in Soler, there were only 4 of us. There was a former politician, a Chinese businessman, myself, and Ragos. And that was when I said I was able to observe his demeanor. And between the 4 of us in the room, there was nothing that would indicate that he was being coerced into saying the things that he did. In fact, he enjoyed the gossip, that he was relaying to us, and he was laughing. So unfortunately, my pañero was not there and did not see the demeanor of Ragos. I did. Second, my point is, yes, there are some instances where the court said recantations can be allowed, but they are, in fact, by way of exception to the general rule. The general rule is still people versus sin. Courts frown upon these recantations. They make a mockery out of solemn trials. They are subject to the caprice of witnesses. And of course, recantations can be bought, either through money or through intimidation. And there is still no guarantee that in the future they will not change their testimony again. That's the general rule. Now, there's also the criteria provided in People versus Ubin, which says that you have to study the 2 testimonies and the context by which they were given. And that's, I think, where the court should have considered the fact that in 5 other instances, including the video interview of Ragos, he affirmed the truth of everything that he studied. So I would submit that on the basis of the criteria of People versus Ubin, then the recantation should fail. And the general rule that it should have been rejected should have been observed by the trial court. Now, I would also like to clarify, I'm not relitigating. As he said, I'm not counsel to anyone in this case. Of course, as an officer of the court, decisions of the court are binding for as long as they have not been reversed by the appellate court. And actually, I'm surprised that an actual lawyer is talking here right now, because I'm not a lawyer. I'm not subject to the litis pendentia rule, or sub judice rule. I have freedom of expression. I can disagree with court decisions. I do so with all due respect to the court. But this lawyer who represented Laila de Lima does not know if government will still appeal that. And he's now talking on a live case, technically, no? Which should not be the case.
But you are saying that the government can invoke due process actually
They
in
can,
appealing.
because the courts now have relaxed the prohibition on double jeopardy. No? If the state was in fact denied its due process, and I think the court can make out a case 5 times. He affirmed the truth and veracity of his statements, and all of a sudden he would recant on the 6th year.
What about the government just focus on the third case, which is similar to the first two, di ba?
Well, I'm not the Solicitor General. I'm not the Prosecutor General. I just read 2 cases, People versus Sin and People versus Ubin. And I think they have a sufficient basis to move for reconsideration first and then to go to an appellate court if need be.
But Harry also mentioned an AMLAC testimony, and si Attorney De Leon is contesting your interpretation of the
Well,
testimony.
I will have to concede with him because he's actual counsel. I'm not. I just read that there was an AMLAC witness mentioned in the court decision. Did not detail what the AMLAC actually testified to, just summarize who were the witnesses. That's the full extent that I know in the case. And what I heard when we investigated the case in Congress and when I personally met with Ragos in the company of 2 other persons. That's
Okay.
all that I know about the case.
Be that as it may, we have heard the president, the former president, say that he is accepting the decision of the court.
Certainly,
And,
all lawyers have
it should
to.
be accepted.
All lawyers, of course, now subject to the right to move for reconsideration and to appeal. But
Well,
as it stands, you have to accept the decision, but it is still subject to motion for reconsideration and an appeal.
Well, the question I'm about to ask has to do with the fact that he is your client and that presumably you're in touch with him. Can you probably expound on where he's coming from, considering that we all know the political history between the former president and Senator Laila De Lima?
That's the
And
thing,
how-
they're barking at the wrong tree. The president, former President Duterte, was never behind the prosecution of Laila De Lima. I am telling you, it was not the former president who introduced me to Ragos. It is a former politician who was a victim of witch hunt of Laila De Lima. So please don't bark at the wrong tree.
Well, but you know, we all
I
know
don't
that.
quite understand
Oh.
why the connection with you. Why does it have to be between you and the former politician? I think we're talking about here the last quarter of 2016, where the president several times in August, September, and October identified Senator De Lima
Right.
as an immoral person who is into drugs, into the drug trade, and said that she will surely go to prison. And now you're saying, of course, that he had nothing to do with the cases.
I do not know about the dates, but I do remember it was the christening for the child of Congressman Mikey Romero, and I, in fact, resented I had to leave because I hadn't eaten at that time. No? But the former politician said, we'll have food here for you anyway. In fact, I said, can I eat first before I go? Because the buffet is very good. But I had to go. No? And the reason, of course, why I was called was I was a member of Congress. And he wanted Congress to investigate the matter. And so I relayed, in fact, this information to the committee chairman, Congressman Umali. And in turn, Congressman Umali then conducted further investigation on the matter before he came up with a decision to actually investigate the matter.
You're referring to
just say-
Mr. Ragos
can I
wanting
just
Congress
say-
to investigate, or the former
The
politician?
former politician wanted
former
Congress
politician.
to investigate.
Okay.
May I interrupt quickly?
Okay, we just need to take a break, but we'd like to go back to the politics that actually drove all of this from the beginning. We'll continue with this conversation after this. Keep it here on the Chiefs.
Thanks for staying with us here on the Chiefs. Still with us, Attorney Dino De Leon, lawyer to former Senator Laila De Lima, and Attorney Harry Roque, former spokesperson for former President Rodrigo Duterte. Attorney De Leon, we stopped the previous episode with you waiting for your turn for a rebuttal. Please
Yes.
comment.
No, I don't think I want to relitigate the past there. No, the court has already spoken. I just want to say this new things that Attorney Harry Roque was saying, that he met Ragos, he saw the demeanor of Ragos and all of these things, it feels like he's testifying on national TV. If he was so categorical about all of these things, perhaps he should have presented himself as witness to the prosecution so that we could have cross-examined him. That's just my point.
ridiculous.
Because, right now, he is saying a lot of things, and these are all hearsay because we can't even confront him in court. And he's not even saying all of these things under oath. So
don't know
that's
what
it.
hearsay
So I
he's
don't
talking
think that
about
we should
now.
actually believe all the things that Attorney Hyrock is saying right now. They are all valueless, considering that he's not under oath and he was unwilling to actually testify in court anyway. So let's not waste our time trying to actually create, facts that cannot be verified anyway. These are all invented, fabricated things, and the court has already spoken.
Let that be his view.
Okay, Attorney De Leon, follow up lang because there are also reports, I think even your campus told us, indicated that after all these cases are settled, former Senator Laila de Lima could go after people who persecuted her. Could you give us some details about this?
Well, we always talk to our client, but the focus of our client is, of course, her defense. But right from the very start, it would have been unnecessary for Attorney Laila de Lima to actually suffer all these things. If she was not just fighting for what she thinks is right, for justice, for the rule of law in our country. And ultimately, even though, as I've always mentioned, and as she always mentioned, even in her dispatches, even if she has already forgiven all her persecutors, the fact of the matter is, it is important to hold them into account because that's how our justice system works. Those who actually use the law and actually weaponize it against human rights defenders must be held into account. And as she always says, there will always be a day of reckoning.
Yes, actually, what message does this send about the justice system in this country?
Well, he was Secretary of Justice. If she did not do any reforms to expedite court trials, then partly she's responsible for it. And that's one reason why we had the parting of ways, because originally I was, in fact, one of those educating her in human rights when she was first appointed as CHR and she was an election lawyer. I invited her to all our forums. But in one gathering in Switzerland, she ended up defending the government. I understand that's her job as Secretary of Justice. But I said that as Secretary of Justice, you have this historic opportunity to actually rectify the weaknesses of the criminal justice system, and it fell on deaf ears because, of course, she had other priorities. So whatever she may have by way of complaints against the justice system, she was complicit because she was Secretary of Justice and Chair of Human Rights. She could have done something to reform the system and did not. Now, let's not forget, she was acquitted on reasonable doubt, and the court said what was established was a widespread trafficking in drugs within Muntinlupa. The court was not saying that she was completely innocent, just that the burden of the prosecution of proving the guilt beyond reasonable doubt was not met.
What could
There's
the
a difference.
prosecution have done better?
Well, I think they should have presented the ABEN, because ABEN was with Ragos when the money was delivered. And the judgment of the court was, without the testimony of Ragos, there's no one that can prove that money was in fact received by Laila de Lima. So I do not know if they presented that guy, Aben, but I do remember that in the House, that Ragos did say that there was always a second person with him, in addition to the fact that he had a driver. Then they should have investigated also the record of visitors in the subdivision. So I'm always wondering why they did not do that. And they should probably have examined also the CCTV to at least establish that on the date that Ragos claimed that he was there to deliver money, that in fact there's evidence that he was present at that time. So I'm not sure why they did not, because I was surprised actually that the CCTV was not offered in evidence, and all private subdivisions already by this time already had CCTV.
Attorney De Leon, what do you think of the third case moving forward now that the two other cases ended up in acquittals, and because these are all criminal cases, and all it takes is really to show reasonable doubt for Senator De Lima to be acquitted? Do you think that there's a reasonable chance also that the third case will end up in an acquittal?
Oh, well, we are always hopeful, though, but considering that this is a live case, criminal case 167. We leave it up to the court, but Senator Laila de Lima always trusts the justice system. She has never wavered in her faith in the justice system, and we just invite the Filipino people to actually pray for her and for this case.
But are you seeing the possibility of an appeal of this second acquittal? Because that's what Attorney Harry Roque has said, that the state might actually push for an appeal.
Our belief is this is no longer a live case considering the prescription against double jeopardy. So they can actually file a petition for certiorari, but that is an extraordinary remedy because a petition for certiorari is supposed to be based on abuse of discretion. And as clearly laid out by the Honorable Court, the court had basis in its judgment of acquitting Senator Laila de Lima, declaring her as innocent. So we don't think that petition for certiorari will actually die in this particular case.
Attorney Harry, let me just ask you about one thing. Ang sinasabi ninyo na hindi lamang napatunayan beyond reasonable doubt yung kaso ni Secretary de Lima. What in effect are you implying? That she is guilty pero hindi lang maiging na ipursu yung kaso o nasa ganung kaso?
Beyond reasonable doubt.
There was precisely reasonable doubt that the evidence against her were not fabricated, but there's basis for reasonable doubt. That's just it.
Yeah,
exactly. That's the meaning of reasonable doubt.
I know, but you brought it up twice already. So
because
what exactly do you want to say?
It's not me, it's the court.
No. You brought it up in this
I did, because that's what the court said in the decision. Why will I repeat what the court said in its decision? I'm basing my assertion of acquittal because of reasonable doubt on the basis of the court decision. It's not my opinion, it's the court. So how else can you change that?
And you think it might have an impact on this third case, the third and last case?
Well, I do not know because I have no idea what that case is all about. As I said, I'm not involved. And my only participation is having met Ragos, probably the first person to have met him when he made these allegations. And of course, my participation in the 17th Congress investigation. So that's the full extent. So I don't even know what the third case is all about.
But
I can't say.
Tony, proving beyond reasonable doubt is the basis for all decisions in criminal cases. So I go back to that. Why are you particular about that? Bring that case that particular condition up?
Because it's in the Constitution. There is a possibility that the crime was committed, except that there was reasonable doubt. I'll tell you one case that I'm handling right now. A person was in fact convicted for kidnapping, sentenced to death. On appeal, the court showed leniency, reversed on reasonable doubt. Guess what? He's back in court again for kidnapping again.
Okay.
That's exactly what I'm asking. That's exactly what I'm asking. Are you trying to imply that? Are you trying to imply something else here? Are you trying to imply that she is guilty pero hindi lang nasagad?
Well, the quantum of evidence required was not met. That's what I'm saying in clear categorical terms, which is what the court said. Proven, not proven, beyond reasonable doubt.
Can I just...
yes, Attorney De Leon, by all means. Yes, please.
Of course, we shouldn't be twisting legal concepts. No? The moment that the quantum of proof is not actually achieved, therefore, the person is considered as innocent because of the constitutional presumption that a person is actually innocent. So let's not say na hindi lang naman na-meet eh. Pag hindi na-meet, ano ibig sabihin nun? Inosente yung tao. At dineclare ng court, acquitted si Laila de Lima, therefore she is innocent because of the constitutional presumption of innocence until proven otherwise.
I beg to disagree because I have actual cases where the courts have said it is dismissed for gross insufficiency of evidence and not just on the basis of reasonable doubt. So it really depends on how much quantum the prosecution was able to prove.
How much of this is really driven by the politics of the season? And how much of this acquittal is also driven by the politics of this season?
From my personal experience, I am telling you, it was not former President Rodrigo Duterte behind the cases against Laila de Lima.
But his pronouncements were to the effect that Laila de Lima was in fact behind all of this drug trade in the Bilibid. His pronouncements. I'm not talking about the, what's being said and presented in the courts.
Well, if there was evidence of probable cause, then the executive, through the National Prosecution Service, really does not have any discretion. They have to file the case in court.
But how much influence did that exert
You know,
on the legal side of
there were
it.
more than 10 witnesses against her. So as far as probable cause is concerned, I think it's there. Even if you were to apply the new standard of Secretary Remulla, likelihood of successful prosecution, I think the standard would still be there for purposes of filing the case in court.
Attorney De Leon?
Well, 10 witnesses that all were incredible, who were not believed by the court, and a lot of them actually proved the innocence of Laila de Lima, including the Anti-Money Laundering Council agent, including the PIDEA agent, who said that there was no investigation linking Senator Laila de Lima to drug trading, by the way. So, ultimately, mahirap siguro yung sabihin natin na yung ginagawa ni Attorney Harry Roque, may panyero here, na sasabihin walang involvement si President Duterte. Well, in fact, all his pronouncements actually say na may involvement siya. Sabi niya bago mag-file kay Laila de Lima, you are finished, Laila de Lima. You will rot in jail, Laila de Lima. And by the way, this was actually cited by the United Nations Working Group on Arbitrary Detention. In fact, the Working Group on Arbitrary Detention of the United Nations categorically declared that the detention of Laila de Lima was arbitrary and specifically cited all pronouncements of Rodrigo Duterte, indicating that there was persecution and this was orchestrated by the state. No, so okay, pwedeng sabihin pa ulit ni Attorney Harry Roque, may panyero here, very respectable panyero here in the legal profession, paulit-ulit niya sabihin yan, pero hindi niya mababago yung mga pinagsasabi ni Rodrigo Duterte, hindi niya mababago ang findings ng experts ng United Nations, at nakita naman ng sambayan ng Pilipino kung gaano paulit-ulit si Rodrigo Duterte na nanggigigil kay Senator Laila de Lima. No? So, Rodrigo Duterte had everything to do with the persecution of Laila de Lima.
Well, with all due respect, Panyero, I think that's grossly misleading. Why? Because before appearing now, I reread the decision, and I read it at least 3 times. The only basis for the reasonable doubt was the recantation of Fragos. There was no statement in the court that the court found that the testimonies of the other witnesses as being incredible. You can read it. No? In the end, the basis for the decision for the reasonable doubt was simply the recantation of Fragos. There was no mention that all the other witnesses were incredible. That's the words of the legal counsel of the accused.
Well, Attorney De Leon, Senator De Lima has been in jail for over 6 years. Kumusta na? She has a 3rd case to hurdle and submitted pa lang for resolution yung bail petition niya. How is that coming along?
Well, as I've mentioned a while ago, Senator Laila de Lima has always been determined that she will actually face these cases on the merits. No, hindi nagtago si Senator Laila de Lima. There were numerous offers before for her to go to exile, for her to just not face the cases. Pero bumalik siya sa Pilipinas. She was actually abroad when the cases were filed. No, so Senator, because if your conscience is clear, napakalinaw ng katotohanan nila sa kanya, maharapin niya yung mga kaso at patuloy siya nananalangin na yung katotohanan rin yung mananaig sa kanya.
Pag na-reject yung bail petition, is yung ginamit ni Gigi Reyes seeking a writ
Habeas
of
corpus,
habeas corpus, petition for a writ of habeas corpus, is that an option for you?
We are exploring all possible remedies to protect the rights of our client.
Attorney De Leon, I understand from a conversation off-cam with Secretary Remulla that they had indeed offered Senator De Lima house arrest instead of being in Camp Crame. But that the camp of Senator De Lima turned that down. Is this true?
Well, this happened nung nagkaroon ng what we call and what we think was an assassination attempt against Senator De Lima in the custodial, the Philippine National Police Custodial Center. No?
Yes.
Kung maaalala ninyo, nabaril sa tabi ni Senator De Lima yung assailant, yung tumalsik pa yung mga dugo sa kanya at that particular point.
Right.
So it was a very traumatic experience.
But wouldn't that have been an opportunity for her to at least spend the rest of her imprisonment at home?
Believe me, Lucy, we actually talked with our client about it. I personally was for it. Pero kasi para kay Senator Laila de Lima, gusto niyang harapin yung kaso sa merits at ayaw niya na magkaroon ng mga special treatment na kagaya noon. No? So for her, sabi niya, mas okay na rin na nandun siya kasi naniniwala siya na hindi na rin magtatagal sana yung kanyang pagkakakulong. No? So that was a decision taken by Senator Laila de Lima on principled grounds.
Attorney, pahabol na lang, I know nasa bail pa lang, pero do you have any timetables in mind? Do you have any idea how long this will last? The third case.
I think there are still 3 settings for the prosecution's main evidence in chief. And after that, of course, there will be remedies available to us, and then it's going to be the defense evidence in chief.
And that would amount to how long? Well, more or less. I know it's impossible to pin it down, pero within the year?
Sana mas maaga doon, no? Pagkatapos natin, upon seeing the evidence, of course, we will exercise all the remedies available to us and hopefully ma-dismiss sa lalong madali pa.
If the bail is granted, do you think that's a sign that, do you think that's a positive sign for the third case?
It's always a positive sign, no? But it is not, there have been instances na kahit mag-grant yung bail, pwede pa rin naman na makapag-presenta yung prosecution. No? So it's a sign because bail will only be granted if the evidence of guilt is not strong. But ultimately, again, we will leave it up to the court to decide because, of course, we have to trust the justice system to let and everything that's happening in the court.
On the justice system, last words.
As I said, no, she was in a position to reform the justice system as Commissioner of the Commission on Human Rights, Chairman, and as Secretary of Justice. She did not. And she now has a personal experience what happens when we have all these ailments in our justice system. I will reiterate my appeal. We need to go back to the inquisitorial system where judges themselves get the evidence and they will then make the judgment after they themselves get the evidence. But really, from the time I handled the Bagindara massacre and all the other cases I've handled, I've said that in criminal cases, particularly where there's no right to bail, then it must be, the hearing must be expedited and it must be conclusive. It must be concluded at the soonest time possible. The only way to do it is a reversion to the inquisitorial system.
Okay. Maraming salamat, Attorney Harry Roque and Attorney Dino De Leon. Thank you for joining us tonight.
Thank you, sir.
Thank you.
Thank you,
Thank you,
attorneys.
attorney.
And that's it for the Chiefs. I'm Edlin Gao.
We hope what was discussed here will keep the conversation going. I'm Ami Pamintuan.
And I'm Luchi Cruz Valdez. We are One News, all sides, all the time.